Hi, Chris Barber here. I'm an attorney down here in Houston, Texas, and as I've mentioned in one of my previous videos, I would go over basically the basic steps of a streamlined, quote-unquote, simple probate here in Texas. The first thing you do is you do need to contact an attorney, and here's a little bit of bonus information. You need an attorney to do probate in Texas, and here's the reason. If you want to go out and sue somebody on your own for yourself, you can do that. It's called pro se, and you can follow through, and there's no problem. However, you can't represent somebody else. That's just the way the law is. Whatever you may think about it, good or bad, well, I don't have any choice in the matter. However, in a probate, you're not really representing yourself, even if you're the named executor. You're representing the person who passed on. So you're representing them, not you. And as a result, you have to be a licensed attorney to represent somebody else. Thus, in Texas, you need to have an attorney to follow through on a probate. And there are more than one kind of probate. The one I'm talking about today will be where there's a valid will and that it's properly self-executed or self-proved is a term they use. And it's presented to the courts for things to be followed through with. And that's the first thing that's done. There's an application made to the court that's filed with the county that says, I want to probate this will. Basically, it's called filing. Once it's filed, the county clerks will post this. It's being done online these days, but in theory, they will literally put a copy of the original will, which has to be included in this kind of probate, and they will post it on the courthouse steps. That's for everybody who may have an interest in the will can know that it's going on. Once a statutory period has passed of this will being posted, it's a little over 2 weeks. It kind of goes like the following Monday after the application is filed. So a little over 2 weeks is a good way to look at it. And then once that happens is you can set a hearing. At the hearing, the judge will go over the will basically, make sure the right things have been addressed, and if everything goes right, the judge will appoint you or whoever's been named the executor as the executor. Another name for executor may just be manager. Think of it that way. The executive is a person who manages the estate once they are giving the authority by the judge to be that manager. The court will also issue something called letters of testamentary. Basically, those are court orders which give you the valid right to go to third parties such as banks or credit card companies or whatever, and it shows that you're the proper person to deal with. Because quite honestly, you can't just walk into a bank and say, hey, I want John's money, I'm the one in charge. You need to have something to give them for they can CYA that you're the proper person to give the money to. And by the way, CYA, I understand, has a meaning other than call your attorney. Once that's done, it's your duty as the manager to go out and collect all the assets that the person who passed away had. You have to catalog these. You have to account for them. What are they valued? You may even have to get appraisers. Under some circumstances, you may have to have a bond because you're going to be in charge of all this property. That gets a little more complex and can be waived if things are done a certain way. Once you do that, you have to identify and notify all the beneficiaries that were listed in the will. That's usually done by certified mail, usually done by your attorney. That way they know they have an interest in the estate, and if there's a problem, they can try to address it. Then you also have to notify all the creditors. As sad as it may sound sometimes, the primary purpose of probate, which is loosely done as means to prove, is you have to notify the creditors and pay the debts. Again, that's probably the main reason for probate in some ways, to make sure all the debts are paid. You can't take it with you, but you can't leave debts behind either. Then once that's done, if there's any problems that come up, it'll be between the attorneys that may be involved and the beneficiaries and whoever else can resolve disputes. Those can be disputes with creditors. Visa says you owe $20,000 and you don't think the estate did. Well, this gives you an opportunity, short of an actual lawsuit against the estate, to try to get matters resolved. So once all the bills are paid and all the disputes are resolved, then, only then, and maybe taxes need to be paid, especially for very large estates, there could be estate tax issues, and any reimbursement to Medicaid if you've got nursing home care, all sorts of different issues like that. Only after that's done can you actually distribute the assets that were left to the named beneficiaries. And that's it. It can be more complex. If there's no will, consider it more complex. And if there is real litigation where you think the will is false or there's undue influence or any of these different situations, it can be challenged. But under a straightforward, quote unquote, simple Texas probate, and this is a simpler process than many other states, it can be done that way. So those are kind of, in a nutshell, the different steps needed to probate what they call an independent administration on a properly signed and proved will. Thanks. If you have a question, call Chris. Give me a call. I'll try to give you some direction. I hope you find the information I shared useful. Have a great afternoon. Bye-bye.